Alright, let's go ahead and start. Let's put phones away. Paper number 2A, it's called, was due yesterday. Raise your hand if you turn that in two formats. Raise your hand if you've turned that in one format. Raise your hand if you have not turned that in. Come talk to me if for some reason you have not turned that in. So again, that's a one-page initial stab at what will eventually be a 5-page paper on the Warren Court. The prompt is on your syllabus, and the prompt is also on today's handout. That 5-page version of that paper, as of now, is due a week from Friday, so Friday, February 23rd. That's what it says on the syllabus. That is the due date as of now. I do recognize a couple of people have asked me about this since I pushed the due date back for the first version. It makes the window tighter in between them. So let me think about that. But as of now, it's due Friday, February 23rd. We'll grade the one-pagers and get them back to you with feedback as soon as we can, but obviously that can't happen instantaneously. And in the meantime, I know you got other classes to work on too, but to the extent that you have time, I would encourage you to work on expanding it even before you have feedback from us. We'll get you feedback as soon as we can, but that doesn't mean just stop. I'll work on it and sit around and wait, right? I'd encourage you to keep going on it. Questions about that? Okay, and we're through a good bit of the first paper assignment too, and again, of course, we'll get those back to you as soon as we have them ready. Okay. So our topic today is, so we're still in the Warren Court era, of course. Our topic today is the women's movement and the Constitution, so gender equality under the Constitution. We've talked about several notable social movements that took place during the 1960s, including the Civil Rights Movement and the anti-war movement, both of which had some impact on the Constitution. Same is true for the women's movement. Take a look at the top quote on your handout. That is what the Supreme Court had to say about gender equality under the Constitution in the 19th century. Bradwell versus Illinois was a case brought by Myra Bradwell, who wanted to be a lawyer, but in Illinois, women were not allowed to practice law. There was a state law prohibiting it. Myra Bradwell challenged that law in the Supreme Court and lost. And the Supreme Court said it was following the law of the Creator in confining women to their natural and proper place in the home. That is pretty well reflective of the constitutional status of gender equality in the 19th century. There was no gender equality under the Constitution in the 19th century, and this lasted for a long time. Women were not allowed to vote at this time. The 19th Amendment was not ratified until 1920. Women were, in general, not allowed to serve on juries. Right? Many states had laws prohibiting women from engaging in certain occupations, such as lawyers, but also sometimes even more blue-collar occupations. There's one case involving a state law that said women were not allowed to work as bartenders unless your family owned the bar. I don't really fully understand that. But I guess the idea was that if your husband or your father owned the bar, you could work there and everything would be okay. Otherwise, women not allowed to work in a bar. Many social insurance and employment policies discriminated on the basis of gender throughout the 19th and into the 20th centuries. So, for example, think about pensions that will allow male workers to support themselves and their families after they retire, or if the male worker dies while he is still of working age, right? So Social Security, for example, if you retire, it gives you a retirement pension, and if you die or become disabled while you are still of working age, it gives a survivor's pension or a disability pension. All of those laws discriminated on the basis of gender, right? They were expressly written to make provision for a family that included a male breadwinner and a female homemaker. That is how the laws were written, right? And so if the male breadwinner becomes disabled while he is still of working age, then the family no longer has any income, and so then the wife and children are going to get a government pension. None of those policies applied in equivalent form to a family where the woman was the chief breadwinner, right? They explicitly discriminated on gender grounds, right? So just lots and lots and lots of examples. Take my word for it. Lots and lots and lots of examples of state and sometimes federal laws that discriminated against women. There were some state laws in the late 19th and early 20th century that you could say also discriminated in favor of women, maybe is the way you could put it for certain laws. For example, some states in the early 20th century enacted minimum wage laws that only applied to women workers. Right? So if you employ women, you're not allowed to pay them less than $1 an hour. If you employ men, you can pay them whatever. So that's a law that I guess discriminates in favor of women. Some of those laws provided important, concrete economic benefits to some categories of women workers, but many feminists at the time opposed them anyway, right? We obviously oppose laws that discriminate against women, but we are also opposed to laws that discriminate in favor of women. Why, do you think? Feminists were opposed to those laws too? Yeah?
Principle?
Yeah, well, what's the principle?
That it's wrong regardless of we should discriminate anyways.
Okay, so yeah, that's part of it.
It also might make for discriminatory hiring processes. If you have to pay a woman $1 and you don't have to pay a man $1, you might limit the opportunities for women.
That's part of it too, and sometimes the laws were even kind of fake. Like it was crafted as if it were a law to benefit women workers in certain occupations, but the actual motivation of it appears to have been to try to keep women out of those occupations by making them more expensive. So sometimes it was really fake. Anything else? Yeah.
If I remember correctly from the podcast, a lot of feminists were not okay with these laws because they were like secretly misogynist. Like they secretly reinforced like really, I guess for lack of a better word, incorrect and unhelpful gender norms.
That's right. Right. So like even a law that on its face provides important benefits to women, if the law was rooted in objectionable stereotypes about gender, right, then many feminists, not like everybody agreed, right, there were different kinds of feminists making different kinds of arguments, but many feminists argued that that law, even though it provides some important benefits to some women, it's rooted in objectionable and offensive stereotypes about women's proper place, right? And so we don't like that one either. We're going to oppose all of them on principle, right? We don't want laws discriminating against on the basis of gender, whichever direction they go. So women's rights advocates challenged all of these policies in the 19th and early 20th century. They challenged them in lots of different ways. They had regular conventional political organizing campaigns. They had protests, and they filed lawsuits. Myra Bagwell filed a lawsuit in Illinois, and she lost. Virginia Minor, around the same time, was a women's suffrage advocate. She filed a lawsuit arguing that the 14th Amendment Equal Protection Clause should be read to prohibit laws that prevent women from voting. She lost in 1875 in Minor versus Happersett. Like 90 years later, all of those decisions were still standing precedents. right? The case about women bartenders, right? Women are not allowed to work in a bar unless their family owns the bar. The Supreme Court upheld that law in 1948 in a case called Gossard versus Cleary. As of 1970, the Supreme Court of the United States had never invalidated a law because it discriminated on the basis of gender. Right? So the Supreme Court wasn't still saying things like this, like not that blatant, right? But they weren't changing anything, right? The law was the same, right? There are lots of local, state, and federal laws that discriminate on the basis of gender. Women's rights advocates sometimes challenged them, they always lost, right? Up until 1970. In the 1960s, the women's rights movement re-emerged. Right? Historians refer to it as the second wave women's movement to distinguish it from the first wave women's movement, which was focused primarily on suffrage. Right? In the 19th and early 20th centuries, achieving the right to vote nationally with the 19th Amendment in 1920. Some states allowed women to vote somewhat earlier than that, but nationally it wasn't until 1920. One thing to note about the women's suffrage movement is it took a really long time. Right? One of the most famous events in that movement is the Seneca Falls Convention here in central New York, 40 minutes from here. That was in 1848. Right? The 19th Amendment was ratified in 1920. You can do the math. That is a long time. Right? It took a long time. It's like a 70-year movement to win the right to vote. Another thing to note about that movement is, of course, it resulted in a constitutional amendment. So that seems notable, right? Significant change to our Constitution. And another thing to note about that movement, so again, on the first wave women's movement here, another thing to note about it is that immediately, right, so the 19th Amendment is a huge deal. That's on your handout too, right? Right of citizens of the United States to vote shall not be denied or abridged on account of sex. That's a huge deal. Immediately, upon ratification, many women's rights advocates started working on another constitutional amendment. Right? All right, that was good. That was a victory. We won that one. We got another idea, too. Immediately, they started working on another constitutional amendment called the ERA, the Equal Rights Amendment. Right? Which says, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. One way to understand this is that the 19th Amendment is like the gender version of the 15th Amendment. Right? 15th Amendment says voting rights can't be denied on account of race. 19th Amendment says the same thing for sex. And the ERA is the gender version of the 14th Amendment. Right? 14th Amendment's got a bunch of stuff in it, but one of the things it says is no state shall deny to any person the equal protection of the laws. And that could potentially mean a bunch of different things. It could potentially include gender equality, but its main original purpose was for sure racial equality. And so we want to put the same thing in there explicitly about gender. Right? Government should not be discriminated on the basis of sex or gender either. That one is not in our Constitution. Right? Remember, it took 70 years to get the 19th Amendment in there. Immediately, they started advocating for the ERA. That one is still not in there. Right? It was first introduced in Congress in 1923, and it has not been ratified. It came very close in 1982. I think it was 3 states short. And last year, Senator Ben Cardin from Maryland reintroduced it. Right? He said, let's try this again. Right? 35-something states have already ratified it. Right? If we just reintroduce it and extend the deadline for ratification, maybe we can get a few more states to ratify it. Maybe we can still get that in there. It's got 3 sections, the ERA, right? Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex, right? So it's like the Equal Protection Clause, but explicitly says sex equality and explicitly applies to both the state and federal governments. Section 2 says the Congress shall have power to enforce the provisions of this article, That's just like Section 5 for the 14th Amendment. And then Section 3 says it'll take effect 2 years after the date of ratification. When it was reintroduced, so it was first introduced in the 20s, right? And there was some debate about it at the time, but it did not go anywhere. It was reintroduced in Congress in the 1970s, and in 1972, both houses of Congress passed it, right? Which then means it goes under Article 5, it goes to the states, and 3/4 of the state legislatures have to ratify it. 22 states ratified it in the first year, but then opposition picked up. By 1978, it was up to 35 states, but yeah, that was 3 votes short. You need 38. And Congress had set 1979 as the ratification deadline. Amendments don't necessarily have deadlines in them, but Congress sometimes puts one in, right? In the bill that Congress passed, it said, in order to be enacted, 3/4 of the states have to ratify this by 1979. Maurice?
The opposition.
Yeah, I'll say a word. I'll say a word about that in a second. So the deadline was approaching. Congress passed another bill that extended the deadline. Said, okay, let's give 3 more years. We're almost there. Give 3 more years. Try to ratify it. But supporters failed to persuade those additional states. And in fact, from 1979 to 1982, 5 states that had already ratified it voted to unratify it, which led all the lawyers to start running around being like, wait, are they allowed to do that? They already ratified the thing. Like, if 3 more states ratify it tomorrow, would it be in the Constitution or not? With 5 of these states saying they changed their minds, nobody knows if they're allowed to do that or not. The opposition, this is a long and complicated and interesting story, and there are lots of different aspects to it, but I can give you a couple pieces of the story. One reason that substantial opposition to the ERA emerged was that there was a conservative backlash against the women's movement, right? So in the 1970s, and even picking up steam in the 1980s, but it starts in the 1970s, there is the emergence in national politics of a vocal and well-organized group of conservative evangelical Christians, sometimes referred to as the religious right, that didn't really exist in national politics prior to the 1970s. It clearly exists in national politics now, right? It emerges in part as a reaction against the women's movement. Some people are saying we got to treat men and women equally. Some people are not convinced, right? Some people think that the feminist movement is an effort to undermine traditional gender roles in ways that will be harmful to the family, right? Some people don't want to change those traditional gender roles, including some women don't want to change those traditional gender roles. And so a political movement emerges to push back. And given the way the constitutional amendment process works, right, you need a vote from 2/3 of each house of Congress. That's hard enough. And then 3/4 of the state legislatures, right? 49 of the 50 states have a bicameral legislature, just like Congress. That means you need both houses of the state legislature in 38 states to support the constitutional amendment. That means if you have 13 states, a single house of the state legislature in 13 states that isn't persuaded, it could even be the 13 smallest states in the country, right? Or the 13 most conservative, or the 13 most liberal, right? They don't have to be representative of the country. It could be any 13 states. They can block the constitutional amendment. It is very hard. You need really substantial national consensus to amend the Constitution, for good or for ill, right? That helps us keep some bad amendments out, but it also might help sometimes make it hard to get some good amendments in, right? So the ERA fails, so that's part of our story here for the impact of the women's movement on the Constitution, right? The first wave women's movement successfully amends the Constitution. It takes 70 years, but they successfully amend the Constitution to guarantee the right to vote. The second wave women's movement, one of its goals, fails to amend the Constitution to prohibit gender discrimination in the law. However, today, all of those discriminatory laws that I was describing, right? What, women are not allowed to be lawyers? Of course that is unconstitutional today, right? The ERA is not in our Constitution, but the Constitution today prohibits blatant forms of sex and gender discrimination, even though the proposed constitutional amendment failed. So think about that for a second, right? We tried to amend the Constitution to prohibit sex discrimination. We failed, but somehow the Constitution now prohibits sex discrimination anyway. Right? That is the main story that I want us to focus on today. Questions so far about the amendments in particular? Okay. So while the constitutional amendment debate was going on, women's rights advocates didn't just sit around. They're like, oh, well, okay, hopefully that thing's going to pass. We'll wait and see. No, that's not really what you do if you're an advocate for some kind of political cause. You're like, all right, that thing's going now. What else can we do to try to push this forward? And one of the things that occurred to women's rights advocates was to push their goals in the courts. Right? They had tried this before. Myra Bradwell tried it in 1873. Virginia Minor tried it in 1875 with zero success. But that's a long time ago. Right? Since then, among other things, the NAACP has successfully litigated Brown versus Board of Education. Right? In the mid-20th century, it seems like the courts might be an avenue for pursuing certain forms of social change where, relatively powerless groups that are in some ways excluded from the rest of the political system are not, their voices are not being heard in Congress or the state legislatures, maybe the courts are a forum where their issues can be heard, right? That's what the NAACP seemed to have done with some success on school segregation, and women's rights advocates are like, maybe we can do something similar. And so a young lawyer who worked for the ACLU named Ruth Bader Ginsburg started litigating some cases. One of the first cases Ruth Bader Ginsburg worked on was a case called Reed versus Reed. A guy named Richard Lynn Reed died, and he did not have a will. His parents were both still living, and they were separated. And each of them wanted to administer the estate. That's why the case is called Reed versus Reed. Mr. Reed versus Mrs. Reed. Right, his two parents. They're having a battle over the estate. And this was in Idaho. And Idaho's inheritance law said that if you die without a will, if you have a will, this is why you should write a will, right? If you care about any of these things and what it's going to happen after you die, you should write a will, then you get to decide, right? If you don't write a will, then there's all kinds of complicated rules where the state has to figure out who's in charge of distributing the property and the like. And Idaho's law said, here's a rank order of family relationships for deciding who would have priority in administering an estate, right? So like next of kin, right? Who counts as the closest next of kin, and we put them in rank order to decide. And it said that when two people are equally entitled to administer, because like they are both your children or they are both your parents, right? They're in the same spot on the rank order. When two people are equally entitled to administer, males must be preferred to females. That was the language of the statute. Sally Reed, the mom, challenged this law, and she won. And to think about how she won in the Supreme Court, and Ruth Bader Ginsburg represented her. To think about how she won in the Supreme Court, go back to something we were talking about previously about equal protection law for a second. So remember the case about school funding from last week, right? So some folks in Texas say, we got this school district here that only gets this much money per kid, and right next door is this other more wealthier suburban district that spends lots more per kid. That seems unfair. We think that violates the Equal Protection Clause. And they lost in the Supreme Court. And Justice Powell, who's a Nixon appointee on the court, wrote the opinion in that case. This is San Antonio versus Rodriguez. And here's one of the things Powell said. The main focus, the main purpose, the main heart of the Equal Protection Clause is about racial equality. That we know was its main original purpose. That's the main example that we have. Right? It doesn't say racial equality. It doesn't say states are not allowed to discriminate on the basis of race. It says states are not allowed to deny you the equal protection of the laws, which sounds like it could mean something broader. Not just racial equality, but other kinds of equality too. But he said race is like the main thing there. It's the main example. We know it was the main original purpose. It's the main example we have in our history of a kind of classification in the law, a kind of discrimination, classification, right? Law treating different groups of people differently, that we should be particularly suspicious of, right? And in San Antonio versus Rodriguez and a number of other cases from the Supreme Court, the judges say racial classifications are particularly suspect, right? We are particularly suspicious of them for obvious reasons, right? Why is the law treating white people and black people differently? That is probably suspicious. Right? We got good reason to be suspicious of that law. And so we're going to look at it really closely. Right? We are going to scrutinize it. We, the judges, are going to scrutinize it strictly. So I got some lawyers' terms for you today, right? So racial classifications are inherently suspect. Actually, the first time the court says that is in Korematsu, the Japanese internment case, when they still upheld it. But they say racial classifications are inherently suspect. And so we are going to subject them to the strictest possible judicial scrutiny, right? We are going to look at them really closely. Judges are always reluctant to say, like, never, right? Just like First Amendment free speech can't really be absolute, right? They don't want to, there's obviously all kinds of, something could come up. Maybe there's some kind of situation in which a racial classification would be allowed. But the idea of strict scrutiny is that it is a really high burden, right? A really high bar to meet in order to justify a racial classification in the law, right? The language that the court sometimes uses to describe strict scrutiny is they say the classification in the law must be necessary to achieving some compelling governmental interest. The example Justice Scalia used to give, he'd say, the only thing I can think of is if there is a prison race riot about to break out, the prison guards can temporarily segregate the inmates on the basis of race to prevent them from killing one another. Right? That is government treating people differently on the basis of race. White prisoners go over there, black prisoners go over there. But if they are trying to forestall a race riot, that's a pretty compelling governmental reason. We don't want these people getting killed. Right? That's racial classifications. In San Antonio versus Rodriguez, Justice Powell says this is not a race case. There, of course, was a race dimension to it, right? Because the wealthier suburban district was majority Anglo, and the poorer urban district was majority Latino. But there was no explicit racial discrimination, and they mostly ignored the race issue in that case. They said here what we have is maybe some kind of discrimination on the basis of wealth, right? Where poor districts are not treated as well as wealthy districts. That's not primarily what the 14th Amendment is about. Discrimination on the basis of wealth. So what you have here is like a two-tiered approach to the Equal Protection Clause. Some kinds of classifications in the law. Classification just means a provision in a law that treats different groups of people differently. Right? Some kinds of classifications in the law are particularly suspicious. We're going to subject them to strict scrutiny. Other kinds of classifications in the law are not particularly suspicious. There's a famous example from the Supreme Court that was some kind of regulation of eye doctors in Oklahoma, and there were different rules that applied to ophthalmologists, optometrists, and opticians who have different levels of training. Right? Ophthalmologists are medical doctors whose specialty is working on your eyes. Optometrists have some lesser degree of training, and opticians have some even lesser degree of training. I do not know all the details. But the law treated those people differently, and like an optician challenged it as a violation of the Equal Protection Clause, and he lost, and the court is like, that is not what the Equal Protection Clause is about. Right? Driver's license laws treat 16-year-olds and 15-year-olds differently. That is not what the Equal Protection Clause is about. We do not have any reason to be suspicious that the government is like unfairly discriminating against 15-year-olds. They are all going to be 16 next year. They will be fine, right? We got to draw the line somewhere. That is not a suspicious classification. It treats different groups of people differently, but it's not suspicious. And so it's just subjected to the most minimal scrutiny. We'll take a look at it. Quick look. You brought your case here. We'll take a look at it. Quick look. Yes, that's fine. Legislature can do whatever it wants. Right? Ruth Bader Ginsburg says, gender classifications should be up here. Right? It is similar to race. Does it say anything about gender in the Equal Protection Clause? No. Does it say anything about race in the Equal Protection Clause? No, it doesn't say that either. Right? Gender is similar to race in some respects. It's obviously different in some respects too. But it is similar in some respects. For example, is there a long history in this country of discrimination against women in ways that would lead us to be suspicious of some laws, like this preposterous Idaho inheritance law that blatantly discriminates against women next of kin? Right? Yes, there is some reason in our history to be suspicious of such laws. So we should look at them more closely. That's what she argues. She's not on the Supreme Court. She's just a lawyer. And she wins the case in Reed versus Reed. But they do not address that argument. They do not say gender classifications are subject to strict scrutiny just like racial classifications. They say this is the kind of thing the Supreme Court sometimes does. They're moving cautiously. Remember, as of 1970, the Supreme Court in its history has never once struck down a law that was discriminating on the basis of gender under the Constitution. So Reed versus Reed in 1971 is the first time the court is doing it. And they are inclined to move cautiously. And the Supreme Court says this. Even assuming that laws that classify on the basis of gender are subject only to our most minimal level of scrutiny, this law is still unconstitutional. Because we can't think of any possible legitimate justification for it. So we are not scrutinizing it very hard, but it still has to be rationally related to some kind of legitimate governmental purpose. And we can't find one. So we don't have to decide if it gets this higher level of scrutiny, because even if it doesn't, it's still unconstitutional. Does that make sense? Does it not make sense? Does anybody have any questions? Yeah.
Was anything else considered suspect at the time? I just find it like ironic, not ironic, but there's so many ways you can be like discriminated against in 2018, but up until 1973, the only thing that we looked at is like race.
It's basically just race at this time in 1971. In 1970, so the school funding case is actually 2 years later. That's 1973, and if you read Justice Powell's opinion in that case, he has a line in there that does make it sound like it could be some stuff other than race. And there's some things that are like closely connected to race, but not exactly race, where you could point to some cases and say, oh, like ethnic or national origin, like there's some cases where the court had looked like they had scrutinized that pretty closely too. So a law discriminating against you on the basis of what country you're from, not exactly what race you are. That's similar, but slightly different. So there were some cases like that before 1971. But it's basically just race. But there are cases. I think Rodriguez is the clearest one, and that's in 73. So at least then, there's cases where they at least are saying, they're not saying it's only race. They're saying at least hypothetically, there are other things that we would potentially think of as similar to race, in which case the same rule should apply. They just haven't identified any of them yet. And in 1971, Ruth Bader Ginsburg is like, I found one. Here's one you should apply the same rule to. And they're like, well, maybe. We'll see. Right? So they strike the law down, but they don't really answer the main constitutional question that Ruth Bader Ginsburg's trying to get them to answer in 1971.
So because they didn't go too into it, because they were cautious,
Yeah.
they put it in the intermediate scrutiny.
Well, we're getting to that. In Reed, they don't have that yet. Yeah. In Reed, they're just in minimal scrutiny, right? There's a famous book about the Supreme Court that is called One Case at a Time, right? This is one of the things. Not always. Sometimes they act more boldly, but the justices historically are inclined, if they are changing the law, if they are changing the meaning of the Constitution, in general, all else equal, they are inclined to do so cautiously. Like step by step. Remember how Brown versus Board of Education was like the 10th case that Thurgood Marshall and NAACP won in the Supreme Court about segregation. It was all these smaller steps leading up to it. Question? I thought I saw a hand over here. So Ruth Bader Ginsburg keeps trying, right? I mean, it's like she didn't get the legal arguments. She won the case, so that's good for Sally Reed. She didn't get the legal victory that she wanted, but this is like a potential step in that direction, right? The court has at least now said that a law can be unconstitutional because it discriminates against women, right? It had never said that before, and now it has said that. So that's like a good precedent, and we can build on that. So she comes back to the court a couple years later, Ruth Bader Ginsburg again, in a case called Frontiero versus Richardson. This is the case that is about military benefits, right? Lieutenant Sharon Frontiero was in the Air Force, I believe, and under military regulations at the time, a service man who was married, his wife automatically counted as a dependent and thus qualified for certain benefits. A service woman who was married could only get the same benefits for her husband if they proved that her husband was actually economically dependent upon her. Like, why does he need the benefits? Why doesn't he have a job? Like, presumably, you see, they don't need the benefits, right? He's not staying at home, is he? What? That's weird, right? What? You got to prove that he's actually economically dependent. Explicitly gender discriminatory in the regulations itself. Sharon Frontiero goes to court. Ruth Bader Ginsburg represents her. They go to the Supreme Court. They win. Supreme Court strikes this policy down too. And 4 of the justices endorse this argument. Strict scrutiny. Gender is a suspect classification like race. Justice Brennan writes that opinion. He says, classifications based upon sex, like classifications based upon race, alienage, and national origin. Okay, so here in 1973, Brennan is mentioned in 3 things, but they are all closely related to race, right? Race, alienage, that's like your immigration status, and national origin are inherently suspect and must therefore be subjected to close judicial scrutiny. He says, he gives some reasons for this, right? He says, our nation has had a long and unfortunate history of sex discrimination, right? Women could not hold office, serve on juries, bring suit in their own names, hold property, etc. He goes through some of that legal history. Women did not have the right to vote until 1920. And it can hardly be doubted, he says that women still face pervasive, although perhaps more subtle, discrimination in educational institutions, in the job market, and in the political arena today. Right? So, long history of discrimination, continued prejudice and discrimination today. That's one reason to consider, to be suspicious of laws that discriminate on the basis of gender. Right? So that history of discrimination and continuing prejudice today, Brennan emphasizes. And there's a second point he emphasizes, another reason why we might want to consider gender classifications to be suspect. He says this, sex, like race, is an immutable characteristic determined solely by the accident of birth. Why is that important? Yeah.
I mean, like, there's educational and wage gaps in, like, between men and women, and that affects your income and affects your child's well-being and affects everything. It's like, it ends your whole life, basically.
So that's true, but connect that to the phrase I just read, right? That it's an immutable characteristic determined by the accident of your birth. Why is that part important?
Because it's really not up to you what you're born as. You just born.
Yeah. What? You're born with one gender rather than the other, and it determines like how much money you're going to make for the next 70 years, right? Or how much access to the political system you're going to have. Like, how is that fair, right? The fact that it is an immutable characteristic. At the time, he thinks it's immutable, right? That's what they're thinking. It is an immutable characteristic determined solely by the accident of your birth. That makes differential treatment on the basis of that characteristic seem unfair, right? Like, it's not like you have more job prospects because you worked really hard for 20 years, right? You have more job prospects because of some characteristic of you at the time that you were born that you didn't do nothing, right? You didn't do nothing to make yourself a man or a woman, right? Or to make yourself white or black, right? You were born with that, so he is describing it as a similarity between race and gender. These criteria, I guess that's the right word, these criteria that he's emphasizing are important because they come back up again and again, right? Because when you start to like spin this out in your head, like, okay, what else might count as a suspect classification, right? Are laws that discriminate on the basis of sexual orientation, for example, are those suspect under our Constitution? There are multiple legal decisions in which judges like go through all these precedents and they try to apply these same kinds of criteria. The immutability one sometimes hangs people up a little bit with sexual orientation and with gender, neither of which are really immutable, right? But are they characteristics that most people are born with and bear no responsibility for? Yes. One analogy that sometimes helps, I think, is to think of religion. Religion is not an immutable characteristic of anybody, right? Many people do, in fact, change their religions over their course of their lives, and it is possible to change your religion. It is not an immutable characteristic, and the characteristic that you're born with, sort of, like not part of your body, but many people are born into a certain faith, right, and raised up in that faith without any choice on their own part. But the fact is that you could change your religion if you wanted. But that doesn't mean government's allowed to discriminate against you on the basis of your religion just because it's not really 100% immutable, right? The idea here is this is a central feature of many people's core identities that does not, or at least should not, bear any relationship to their worth, right? You are born with a certain race or gender or religion. You are raised up in that. That should not lead us to treat you better or worse as a political society, right? And so if we are talking about a characteristic that people are born with and doesn't easily change, and it's a characteristic on which there's some long history of and evidence of prejudice and discrimination in our society, and then we see a law that treats people differently on the basis of that characteristic, we should be suspicious of that law. Maybe the government has some really, really good reason for that law, but if they don't, I'm pretty sure it violates the Equal Protection Clause. That is the logic of the argument here, right, that Ginsburg is pushing. Not saying that like gender and race are exactly like each other. Obviously they're not exactly like each other, but they're similar in this important respect, in these two important respects, right? And so just as we're suspicious of laws that treat people differently on the basis of race, we should be suspicious of laws that treat people differently on the basis of gender. And unless the government's got like a really good reason, the courts should probably strike those laws down. That's Ginsburg's argument. And in Frontiero versus Richardson, it is adopted by 4 of the Supreme Court's justices, which is not quite a majority, which means the Supreme Court as a whole has still not adopted that argument. Right? Frontiero wins. Ginsburg wins this case too. Right? Lieutenant Sharon Frontiero wins the case. But she does not win a full endorsement from a majority of the court of the key constitutional argument that she is making. Yeah?
2 things. Well, I guess 2.5 things. Was the Frontiero decision unanimous, or was there dissent?
It was 5-4, I believe.
Okay, this took place at the same time as, like it was 1973. The Nixon appointees were.
The Nixon appointees are there.
There.
Yeah.
That I just think is interesting that they were.
Yeah.
On this facet. 1, 2. The other thing was I think that I guess. Lawyer, Justice Ginsburg.
Yeah.
But
yeah.
I think
Lawyer Ginsburg. Yeah.
Yeah, it's very impressive that she had like she didn't try to reinvent the wheel. She was like, the 14th is there.
Yeah.
They've been using it very effectively. And just use what they've been like.
That's what lawyers do, right? Sometimes it takes some creativity. Like, if you're a lawyer and you want to win a case, you cannot walk into court and say, judges, please do something like brand new that nobody's ever heard of before. That does not work very well. Like, judges don't do that, right? Judges of any political stripe do not do that, mostly. Right? Now, I can give you some exceptions, but mostly, right? That's not what judges want to do. Like, that creative lawyering, lawyers and judges can change the meaning of the law over time, right? But mostly you do that case by case, kind of one step at a time, right? Lawyers talk a lot about reasoning by analogy, right? Even not in like famous constitutional cases, just in like ordinary legal disputes. Well, we got this contract dispute, where so-and-so was supposed to do this, but the guy on the other side of the contract didn't do this, and, they got this disagreement, does she have to do her side or not? Well, remember that other case from 10 years ago where there was a contract dispute that was kind of like this, and the judges said X, Y, and Z. Well, this is not the exact same thing. This is a slightly different situation here, but it's kind of similar to that. So we think the same rule should apply, right? And then a few years later, another case comes up that's not the exact same thing, but is again kind of similar, and we think the same principle should apply. And so reasoning by analogy like that from case to case to case, a principle can get extended in particular directions. Right? And so that's what Ginsburg's trying to do here. And she's having some success, but it's incremental success, right? She is winning the case. She's winning the cases for these women who are being discriminated against. And she is persuading the Supreme Court for the first time to strike down some laws that discriminate on the basis of gender. And she is pushing them slowly towards declaring some kind of clear constitutional principle about how the 14th Amendment Equal Protection Clause applies to gender. What happens in this case, in Frontiero, the justices do this sometimes, so there's 9 justices, they hear the arguments in the case, then they vote in secret, and then they know which way it's going to come out, and then they assign somebody to start writing the opinions. But sometimes they can't really agree on the arguments, sometimes somebody's vote shifts over time while they're debating and deliberating and drafting the opinions. Sometimes there's 5 or 6 or 7 or even 9 justices who agree on the outcome, but they can't all come to grips with one opinion that they can all sign on to. And what happens in those cases is that the court's judgment is announced by a plurality opinion, right? Plurality means the most votes, but less than a majority. And so Brennan's opinion, 4 justices agreed to it. That was the most, but it was not a majority. And the result was joined by Justice Powell. No, not Justice Powell. Anyway, one of the justices, maybe Justice Powell. Anyway, some of the justices joined the court in the result, but they did not sign on to Brennan's opinion. Yeah, Justice Powell was one of them. Yeah. So, like, I agree Sharon Frontiero was discriminated against and it was unconstitutional. Just like we said in Reed versus Reed. This is what Powell says. We don't got to decide this big question. I'm not sold on that yet. But Sharon Frontiero should win the case for sure. So we got at least 5 votes to decide the case. But we only have 4 names signed on to Brennan's opinion, which means the case is done, Sharon Frontiero won, but there is no precedent established. If a majority of the sitting justices do not sign the opinion, it is not a precedent. Right? So Ginsburg's question is still unanswered. Right? And another case comes back to the court in 1976 called Craig versus Boren. All these cases are listed on the handout. It should be. Yeah. So Craig versus Boren in 1976 was from Oklahoma, which had a law that said women could legally purchase alcohol when they turned 18, but men had to be 21. It was low alcohol beer, 3.2 beer is what 18-year-old women were allowed to purchase. It was not that great. Tastes like water. But they could get something. And men had to wait till they were 21. And some, 19-year-old men in Oklahoma challenged the law as unconstitutional. And Ruth Bader Ginsburg represented them, right? Just like back in the early 20th century. I guess this law is discriminated in favor of women, right? They can buy 3.2 beer 3 years before everybody else. But I still don't like it. Right, it is rooted in some... Why? Why would we have a different drinking age for men and women? What is that based on? What? I don't think the law should do this. Justice Ginsburg, Lawyer Ginsburg says, right? So she challenges this law too. The state's argument was they had some data to show that rates of drunk driving were significantly higher for young men than for young women, right? So they said it was a public safety justification. They did have some evidence for that. There was some correlation between gender and rates of drunk driving. Supreme Court said that's not good enough. We don't think that's adequate to justify the discriminatory law. And Justice Brennan wrote the opinion in this case again. And this time he had a majority, but he adopted a different argument than he did in Frontiero, which is why he was able to get a majority. He compromised and got more votes. He says we're going to have 3 categories instead of 2. The justices aren't super good at settling on one clear term and sticking to it case after case after case. But I think the clearest term is, think of these as, there could be some intermediate category classifications that are semi-suspect, maybe not quite the same as racial classifications, but more suspicious than a law treating optometrists and ophthalmologists differently, right? Semi-suspect. So we're going to apply some intermediate level of scrutiny. That's what we'll do. Gender classifications are semi-suspect, the court says in Craig versus Boren. And so we will scrutinize them pretty closely, although not as closely as racial classifications. And they strike down the law from Oklahoma. Ginsburg wins again. And this one is issued by a majority of the court, so this one is a precedent. And this is more or less still the governing standard for gender classifications in the law today, although Ruth Bader Ginsburg, once she herself got on the court, if I have time, I'll tell you about this case, she seemed to tweak this one a little bit and maybe make it a little stricter when she was writing the opinions. But it's basically still the same standard. There has never been a case. The court has never issued a decision that said, or a majority of them said, gender classifications are just like racial classifications in the law. They're highly suspect. We're going to subject them to strict scrutiny. They have never done that. Right? A couple things I want to say about these developments. And so then these different levels of scrutiny, right? So think about in free speech, right? Think about categorical and balancing approaches. So basically, I think the right way to think of this is it's obviously a categorical approach of some kind, right? Here are 3 different categories of discriminatory classifications, and within each category, we have a sort of balancing approach, but it's a different approach for each category, right? Sometimes people are like, oh yeah, these ones are automatically unconstitutional and these ones are automatically constitutional. That's not quite right. There's a balancing approach in each category. These ones are for sure leaning that way, and these ones are for sure leaning the other way, and these ones are in the middle, but it's a balancing approach in each category. And the gist of it is, we're going to look at what is the state's purpose, why are they enacting this discriminatory law, do they have some good reason for it, and what's the connection between that purpose and the actual discrimination. Like, is there some, like, did they just make up some purpose that doesn't really have anything to do with this? That wouldn't be good. Right? So they're looking at the ends and the means. What's the purpose, and what's the connection between this law and that purpose? And they just use different adjectives at each level of scrutiny. Right? Is the law rationally related to any legitimate governmental purpose? That's the lowest standard to me. In gender cases after 1976, they start to say things like, is the law closely connected to any important governmental purpose? Not just any legitimate governmental purpose, but an important governmental purpose. And up here in strict scrutiny, they say, is the law narrowly tailored? Or sometimes they say, is it necessary to achieving a compelling governmental purpose? Compelling is a stronger adjective than important. Important is a stronger adjective than legitimate. Right? And so they're just ratcheting up the scrutiny. Okay? So, a couple things I want to say about these developments. One, the meaning of the Constitution clearly changes. Right? Remember, the ERA was proposed to do exactly what we are here now doing, and it is not in the Constitution. And yet the court is doing it anyway, creatively reinterpreting the existing provisions that are in the Constitution, which potentially apply. Right? No state shall deny to any person the equal protection of the laws. A law that says male next of kin are automatically preferred to female next of kin in administering a deceased person's estate. That for sure sounds like it denies somebody the equal protection of the laws, right? So they're not making stuff up out of thin air. They're taking a provision of the Constitution that potentially applies, but they're applying it to situations that it was not previously applied to. So the meaning of the Constitution seems to be evolving here. Right, that's one thing. Second thing, why doesn't the court go further? Right? Like, why doesn't Ginsburg win all the way on this? Right? The women's movement is like calling our attention to all kinds of patterns of sex and gender discrimination that previously society was not paying much attention to, and like now we're aware of them and we're going to try to get rid of them, try to push past. There's a lot of political support for this. Right? Ginsburg makes some good legal arguments. Why don't they just go full on and say the law should not be discriminating against women? There's at least two kinds of reasons. There's more kinds of reasons, but here's two. One kind of reason is something that Justice Powell says, which is about the appropriate process for changing the Constitution. Justice Powell, in Sharon Frontiero's case, writes a concurring opinion So he agrees that Frontiero should win the case, but he refuses to sign Brennan's plurality opinion with a strict scrutiny in it. Justice Powell says, so wait a minute, I would just like to point out here that we got this whole constitutional amendment debate going on right now. Like the ERA has just been proposed by Congress, right? It was passed by Congress in 72. It's out there in the state legislatures now, actively being debated. Is it me, or are we right now doing the exact same thing that amendment would tell us to do if it were enacted? Like, why are we doing it now if the amendment is like, they're like, the people are debating the amendment right now. Shouldn't we give them a chance to have that public political debate and decide whether to amend the Constitution or not? Why are they having that debate if we're just going to change the meaning of the Constitution by ourselves? That is not an unreasonable question. Ginsburg has an answer to that question, but it's not an unreasonable question, right? What is the point of the constitutional amendment debate if the Supreme Court is just changing the Constitution by itself to do the exact same thing that the constitutional amendment would say? Right? Powell's like, let us let that process play out. A second kind of reason that the court never fully adopts Ginsburg's arguments is that some of the justices and some of the American people, more broadly, are not persuaded that gender is just like race. It's obviously not just like race, but in relevant respects, they are not persuaded that we should think of gender in the same way that we think of race. In particular, some people, by the 1970s, are convinced that your race has nothing relevant to do with your moral worth in our society or what kind of things it is appropriate for you to be allowed to do in our society. But they are not equally convinced of that with regard to gender. In other words, some folks are now persuaded that white persons and African American persons are more or less the same, but they are not persuaded that men and women are more or less the same in certain relevant respects. In other words, there are some things that men should be allowed to do that women should not be allowed to do, because men and women are different. Innately, inherently, biologically different. Even though, okay, yes, some of those old laws we had, women can't be lawyers, that was a little ridiculous. Okay, I'm glad we got rid of that. But should women be allowed to serve as combat soldiers? Maybe I'm not ready to go there. Right? And so the judges, like some other American folks, regular people and lawyers and legislators and everybody else, the judges are like, if we say this, if we say we're going to scrutinize gender classifications in the law just as closely as we scrutinize racial classifications, then we got all these examples popping into our minds of things that might not be allowed anymore. Right? Ways in which the law currently treats men and women differently that we think are in fact appropriate and justified, and we are not prepared to get rid of. And so we are reluctant to go to this high standard. Can we come up with something down here a little bit that would still give us some more wiggle room to uphold some of those discriminatory laws? The issue of military service comes to the court in 1981. So we're jumping forward in time here. Bear with me. In a case called Rosker versus Goldberg in 1981, the Supreme Court upholds the male-only military draft system. Right? Selective service law says men, when they turn 18, have to register for the selective service, which in cases of military need will be used to draft soldiers. Women do not have to do that. The law was, of course, challenged by men, right? It was not challenged by women. The law was challenged by men who argued that they were being discriminated against by being forced to sign up for some mandatory government obligation that half of their age cohort was not being forced to do. The Supreme Court upholds the law in Rosker versus Goldberg. Supreme Court, this is after Craig versus Boren, so Supreme Court claims to be applying this intermediate level of scrutiny, right? That's the adjectives they use. Is this law closely related to some kind of important governmental purpose? And the Supreme Court says yes. They say in contexts in which men and women are similarly situated, that's the way lawyers put it, right? In contexts in which men and women are similarly situated, then the Equal Protection Clause prevents the government from treating them differently. But in contexts in which men and women are not similarly situated, the Equal Protection Clause allows the government to treat them differently. Young men and young women are not similarly situated with respect to military combat, i.e., according to testimony of the civilian and military leaders of the armed forces at the time, men can be combat soldiers and women can't. And so, because of the physical differences between men and women's bodies, this discriminatory law is allowed. Anything wrong with that argument? Just take it as a given that on average, the average American man is going to be better equipped to perform whatever physical tasks are necessary to military combat than the average American woman.
It's not in every case. There are cases that exist where women are far more physically fit than men.
That's the problem, right? The average American woman might not be a very good combat soldier. I know a lot of American men who would not be very good combat soldiers too, right? Like, are there some women who are capable of doing it and who want to do it? The answer is quite obviously yes, right? And so why would the blanket discriminatory policy be justified because, like, on average, whatever, you got to do, like, how fast you got to go a mile with a heavy pack on your shoulders, whatever kind of tests they want to do for combat training. Are there some women who can do it? There for sure are, right? So, like, why would the blanket rule be a legitimate justification if there are some people for whom it doesn't apply?
Because the infrastructure of the military wasn't set up for females to serve like with men. It still isn't, but it's getting there.
Right.
So for kind of learning on the fly.
For sure, that was part of the argument too. Right. We got to change everything up if we got women in here. Right. Housing, bathrooms. Like, what are we going to do? Like, we got a lot of changes we can make. A related case, again, we're jumping forward in time, a related case comes to the court in 1996. It's not about the U.S. military, but it is about the Virginia Military Institute, which is a public university in the state of Virginia that's a military academy. Right? Virginia Military Institute, long and distinguished history, has trained many people who've gone on to success in military and civilian careers. Lots of leaders in the state of Virginia, government leaders, corporate leaders and stuff among their alumni. And it had always been male only. And there were women who challenged this admissions policy. They wanted to attend VMI, and they were, at least some of them, were able to meet all of its admissions requirements, right, which included various physical tests as well as SATs or whatever. And VMI refused to admit them, and they challenged it, and they made their way to the Supreme Court, and they won, and Ruth Bader Ginsburg wrote the court's majority opinion in the case. And she is like, look, I've seen a long history of this. Like, is there some, like, coherent reason you could come up with for why VMI was initially created as all male? Yes, of course, right? But operating today, right, it's a public university, right, providing a benefit, public state-subsidized benefit to the people of the state of Virginia, and half of the college-age population is just blanket excluded from applying, right? And some of that half are interested and fully able to perform all of the tasks that are required for admission and successful completion of the degree, right? And the only reason they're now being excluded now, I don't know about 100 years ago, but now, the reason they're being excluded is because people still have these outmoded conceptions of what is or is not appropriate for women to be doing. Right? We want to keep it all male. Virginia Military Institute made all kinds of arguments about how, well, we're going to have to change everything up. The whole college is set up in such a way that, there's no women around. Like, it's going to complicate some things if we got women up in here. We're not going to be able to, they argued that they're not going to be able to use the same curriculum because, and some of the testimony in court was a little weird, right? I mean, there was like a fair amount of like, I got nothing against VMI, I don't know that much about it, but in reading the descriptions of it, sounded like organized hazing, right? Like supervised and like tolerated by the people in charge of the university in an effort to break down the individual, right? And then build back up as a group, that kind of thing, right? Part of the military style training is this form of upperclassmen, like directly and aggressively supervising underclassmen. We're not going to be able to do some of that stuff if we got women in here. And Justice Ginsburg's like, I'm not telling you got to change the curriculum, but that is not a justification to exclude women from the university. Is it a good educational philosophy, what you're doing, or not? Is it not a good one? If there are women who want to attend and participate in this curriculum and learn in this environment, and they are capable of meeting the entrance requirements, you have got to admit them. And this is the case where I said the court is technically still using this same intermediate approach, but if you read Ginsburg's opinion in U.S. versus Virginia, her language sounds stricter, like her adjectives sound stricter than Justice Brennan's did in the Oklahoma 3.2 beer case, right? Craig versus Boren. One of Ginsburg's phrases is any kind of law that discriminates on the basis of gender must have an exceedingly persuasive justification. That is like stricter sounding standard than what Brennan had said in 1976. They still don't say it's strict scrutiny. They still don't say it's exactly the same, right? Compelling governmental interest is required, but she says exceedingly persuasive justification. Sounds pretty strict. Justice Scalia writes a dissenting opinion in this case, and he says the court won't admit it, but they're basically applying strict scrutiny now. Right? They're not using the words we usually use for strict scrutiny, but they're using some other new, made-up words to basically apply strict scrutiny. I don't think we should do that. Justice Scalia says, I know we got all these precedents here, so I'm not sure. When you write a dissenting opinion, you can kind of say whatever you want, right? Because it's not really part of the law, so you can kind of think out loud and speculate and stuff. He's like, I know we got all these gender equality precedents now. I'm not sure if I would overturn all of them, but if you had asked me at the beginning, I would have said, this is the right standard. Right? I'm back with how the court was in the 1960s. The 14th Amendment's got nothing to do with gender. That was not part of its purpose. It's not explicit in the text. The ERA was not adopted. I'll go back to that. And in fact, he says, and this kind of echoes, this is Justice Scalia in 1996, and it echoes